seated. Good morning, folks. Please be seated. Okay. Do we not have Mr. Matos?
Ready to bring it in.
Okay. Perhaps at the podium with the defense counsel. Okay. This is case number 14-05586 in the interest of Adam. Is it pronounced Matos or Matos, Mr. Littlemore?
Matos. Matos. I get it wrong all the time.
Matos.
Matos.
I wanted to find out specifically what the status of the progression of the case is. Perhaps I could hear from Mr. Sarabia first from the state as to the state's discovery, assistance, and moving the case along.
Judge, I believe that all of the reports at this point have been discovered to the defense attorney. There are some very minor things that we still have the detective doing that will go out as they get done. Nothing that I believe will be earth-shattering or unexpected.
Let me ask you specifically about any lab issues and experts in that regard, because typically there's a delay, I believe, in getting that type of
Yes, Judge.
witness and evidence.
There were approximately 150 items collected that we may want to send off to the lab. Some of them are more useful than others. The lab is only accepting 30 at a time, and they're only on the first batch of 30, and it's been about 5-6 months now. I believe they're getting close to finishing processing those. And
Specifically September 6th, and then arrested on September 15th for discharge.
Right. I am hopeful that they will be able to process some of the items, the later items, quicker, because I think the earlier items were the more complicated items. But we have another batch of 30 going down either yesterday or today, because we're trying to push them to accept more and get working on more.
Mr. Sarabia, that isn't acceptable. It just isn't acceptable in the scheme of things. If I had received the information as I've just received it, it was my anticipated action to set this for a status or a pretrial in 2 weeks and have the state subpoena the head of the FDLE lab to explain why they're proceeding at such a glacial pace.
I don't know that that'll be necessary 2 weeks out, but we can, again, we are working with them. We're trying to push them as fast as we can. I think they try and keep the same analysts involved in all aspects of the case so that there aren't 7 analysts that have to come in and testify
I
about.
don't care if there are 7 analysts. This can't drag out because of lab technician availability.
Okay. I will be in contact with them.
Any other issue that affects the setting of the trial?
Any other issue in terms of things going on in the investigation, or as far as the depositions? I think we've done approximately 13 depositions. We had a deposition date earlier this week. I've made multiple dates available to the defense and to set as many opponents as they need to. There's another deposition date in February. There are approximately 320 witnesses listed, and 16 of those are out of state. 6 of them are out of county in excess of 2 hours away. And that's not including if there are additional lab analysts who become involved through
Has the state complied with the rules of criminal procedure as to designating certain witnesses?
Yes, Judge, I believe so.
Or have you just listed 320 witnesses?
But then we've listed 320 witnesses who we believe may have information relevant to the case in one direction or the other. I do not anticipate calling.
I find that hard to believe, honestly. I mean, the state isn't listing witnesses who might be a deputy that was one of 10 deputies that secured the scene, are you?
Then we are required to list all of the witnesses that may have relevant information, and those deputies can say that the scene was kept secure, that nobody entered or left without their knowledge. And at times, that evidence becomes very relevant. I believe in the DeTullio case, we ended up calling several of those people to testify regarding Mr. DeTullio's movements through the crime scene did not go across a path of blood as he was claiming unexpectedly during the course of the trial. So there are certainly witnesses with much less relevant information than other witnesses, but at this stage we've listed all the witnesses that we feel could have relevant information to prosecution of Mr. Matos or potentially to the defense of Mr. Matos.
Have you worked with defense to advise them of those witnesses that simply have a very, very remote relationship to this case so that it isn't necessary to depose them?
I did speak with Mr. Livermore about that. We did meet pursuant to your request at the last pretrial hearing. And I believe those are the witnesses he has started deposing, and he has been setting them in mass for the different deposition dates. The 13 witnesses I mentioned previously, they were actually all deposed in a 2-hour period that Mr. Livermore set with my office.
Okay. Is there anything else that you can offer to the court relative to efforts to move this along so that you reset the trial?
Judge, I believe that about covers it.
Mr. Livermore.
Judge, you know, the case law says that it's presumed effective assistance to not depose the witnesses. So it is our intention to depose the witnesses. We're talking about witnesses in Florida, Georgia, Pennsylvania, Kansas, and California. That's not counting and not even considering penalty phase because the state is seeking death on this case. I know there's family in Pennsylvania, and I know there's family in California. All I can say is that we'll do what we can, but it is not going to be quick to get all of this done. I'm meeting this afternoon with a mitigation specialist in the hopes of hiring someone to help with mitigation on this. We have.
Interrupt you. So you're preparing concurrently with the mitigation as
Absolutely, we have to, yes. And most everybody here is from Pennsylvania, so I feel most of the families from Pennsylvania, so I'm pretty sure we're going to end up there trying to find people to, for the penalty phase. I don't see this being ready anytime in the near future, frankly. There's just too much to do and too many witnesses.
Have you considered conferring with the state, winnowing down the witness list so that witnesses who are very ancillary and may have no only connection to the case may have been driving somebody to a crime scene or something or other, that can be confirmed under oath at deposition, and typically they take about 5 minutes.
That's all we've been doing. We set, we have the normal no-shows and have to resets, but we set, I believe, 20 people in a 2-hour period. And we got through them because you could kind of tell that they had nothing to offer. One of them did, and that's the problem. You never know until you depose them that they didn't tell somebody something. So I don't know what else to tell you. We're going as fast as, I've got trials set every 2 weeks on the, coming up, so it's not like I can put full time on this case. I do have 2 other lawyers, and we're going to start dividing it up, but that's the best I can tell you. And my next question is, I was ready to file 2 of the death penalty motions, and I was told that we weren't sure who was going to try the case, so I'm not exactly sure where that's going either.
7 before me.
Okay.
Judge, we were going to ask for some hearing time, maybe in October for all motions. We have some motions that are going to require testimony or evidence for the Williams rule, and we're going to be filing a motion to admit cited items.
Why don't you try to set it earlier?
Is there a good time that Your Honor would recommend?
I'll make time. Now, one thing that concerns, many things concern me, but what one matter defense counsel brought up concerns me, and that is the issue of no-shows. I recognize that if you're talking about law enforcement officers and a deposition, that sometimes emergencies come up. And an officer may not legitimately be able to show for a deposition. But 7 out of 20 witnesses not showing up for a scheduled deposition does stretch that premise.
I'm sorry, I want to understand you on that. I think we had, I'm trying to count, I think we actually had 1 no-show, and then we had 2 or 3 that were out of town on vacation or for some other reason couldn't be there. There weren't 7 no-shows. I may have misstated that. There were probably 4 or 5 that we had to reschedule. And that's going to happen, and people move and, all that kind of stuff. None of these were law enforcement.
I see. I would like the state to, in effect, ride herd over your witnesses, change of address, phone numbers, contacts, and somebody doesn't show for a deposition. I know you typically do this, but I would really like this to be emphasized, follow up on it, find out if they've moved to Orlando, so you can get a new address quickly. Have your investigator contact them. Tell them they were set for a deposition last Tuesday. Obviously they didn't appear for certain reasons. They're going to be redeposed on the 15th of February. Is that going to work?
Certainly, Judge.
Particularly, of course, if they've moved to another county and
My understanding,
they have to set it in that other county.
I believe there were only 5 witnesses who were not deposed who were scheduled for deposition, and 4 of those had already made contact with the public defender's office to schedule, I believe, the next deposition date, which we just tacked them on, anticipating that we can go through them quickly. There was only 1, I believe, who was served, and we did not hear from. But I will look into that.
Okay. I would like to set this for a next status hearing in 2 weeks. Is counsel available on 2/12/15 at 8:30?
I'm sorry, what day of the week is it?
Thursday.
I'll do that.
I have a little trouble with the electronics.
I have so much trouble, I don't have it.
I have a pretrial with Judge Syracuse at the same time,
I heard the pretrial, but I didn't hear what.
with Judge Syracuse at the same time, but we can dance back and forth, that's fine.
We work well together. So, is that agreeable with the defense?
Yes, sir.
Great. I'll set the status for 2/12/15 at 8:30. Now, getting back to the lab, issue. Counsel,
Yes, sir.
if you get an agreement worked out so that they put these on the front burner instead of the back burner, within the next few days, you need subpoena the head of the laboratory for that hearing. Absent that agreement, I want she or he here.
Yes, sir.
Explain to me what in the world is going on. Okay?
Yes, sir.
All right. Mr. Livermore, is there anything that you can think of that I could do, that I could offer to do at least, to assist?
Not at this point, Judge. No.
Are there any motions for costs that you would anticipate?
No, all our money, all of our experts come out of the due diligence fund. We don't do the cost thing anymore. So it just has to be approved by the boss, and he does not hinder that. That's not an issue.
Okay. Anything further by the state?
No, Judge.
Anything further by defense?
No, sir.
Thank you very much.
Thank you.
Uh,